Hello, folks. We're going to get started in just a moment, but it is almost 1 o'clock, and I appreciate some of you for joining a little bit early. There's no extra credit for joining early, but appreciate you joining us this sunny Friday afternoon at 1, and we're going to get underway momentarily. Hello, everyone. I see folks are starting to join the webinar, and we are live streaming. It's 1 o'clock, so I want to kick things off. Good afternoon. Here in Albany, it is absolutely gorgeous outside, so I know the opportunity cost of joining us this afternoon and learning about SEQRA is time perhaps not enjoying the sunshine. So extra credit today for those of you who are taking the time this afternoon to join us and sharpen your skills. Today, we're going to talk about the State Environmental Quality Review Act, and we have a couple experts joining us today from AKRF, Aaron Werner and Jason Mencher. Before we get to those folks, I do want to give a brief introduction and shameless plug for our Technical Assistance Program, CDRPC, and I'll call it our sister agency, Capital District Transportation Committee, are currently accepting applications for technical assistance. We've worked with communities across the capital region in the 4 counties that we work in, Saratoga, Schenectady, Rensselaer, and Albany, on transportation and land use initiatives, better planning to deliver public services to folks in communities within the Capital District, and really take a look at an integrated solutions approach to planning in communities. So encouraging people to check that out if their community has a particular need or they are interested in applying for that particular program. A couple of housekeeping notes. Our attendees join with video and audio off. If you joined us before, you're used to this setup. Please use the chat function or the Q&A function to put in your questions. We will archive those, and our presenters will be able to get those to those at the conclusion of the webinar. In addition, we are recording, and we are going to post that on our Eventbrite page, the same page you used to join us. And so if we do happen to run over, if there's something you missed, if you'd like more information about a particular slide and you want to get back to it, don't worry. We are archiving the presentation. You can come back and view it again to catch back up. And if you have any questions about today's webinar, just reach out to us at CDRPC and we'll be able to pass those along. So please use the chat function, use the Q&A function, and we can be sure to relay your questions or comments to our presenters. And finally, exactly 24 hours after the conclusion of the webinar, we have an automated email that is sent out via Zoom, and that confirms your attendance. Municipalities have a wide latitude in accepting these types of trainings for your 4 hours of planning and zoning credits each year. So this session may be submitted to your municipality. It has also been submitted and received at CM for you AICP folks out there. This is on the American Planning Association website, and it has been certified. Okay, housekeeping out of the way. This session will provide an overview and intent of the application of the State Environmental Quality Review Act. I call it SEQRA. It covers both substance and procedure. We'll discuss classifying the action, lead agency determination, negative and positive declarations, EAs and EISs, the difference between those two forms, the significant adverse environmental impacts of potential projects, mitigation, public hearings, and preparation of environmental findings. There's going to be a lot covered, so I'm really glad we have the full hour. We'll also review recent SEQRA updates and best practices for municipal boards. And I told Aaron and Jason I was going to do this because we actually have, I don't want to say a little bit of controversy, but we found among ourselves, we pronounce SEQRA and SEQRA. Some of us pronounce it differently. So I put up a poll that folks can take. How do you pronounce it? Do you pronounce it SEQRA or SEQRA? We're seeing the results come in, and folks are starting to address that question. And hopefully I'm going to be able to display the results. I had trouble displaying the results of the poll previously. If I hit share results, can folks see? So 9 of the 14 people who have joined us pronounce it SEQRA, and SEQRA is 5 of 14. So SEQRA takes the cake, but not by a long shot by any means. So a narrow margin. So. All right, Aaron and Jason, take it away. Put me out of my misery here. Let's get into it.
And to be fair, we'll use both. So,
so no one will be upset about the pronunciation. So
sounds good.
Thanks, folks, for taking that poll.
Okay. Get my screen set up. Give me a second.
Looks great.
Everything there?
Yeah, looks great.
Great. Okay. Well, alrighty then. Well, thank you, Martin, for the great introduction. It's great to be here again and continue to help support the great work that CDRPC is doing. Good afternoon. My name is Aaron Werner. I'm a planner with AKRF's Hudson Valley office. We're a multidisciplinary environmental planning and engineering consulting firm with offices in New York City, the Hudson Valley, and the Capital District. We also have offices in Connecticut, New Jersey, Pennsylvania, and Maryland. I'm joined today by my colleague, Jason Mencher, another planner from our Hudson Valley office. And we're going to talk about the New York State Environmental Quality Review Act, also known as SEQRA or SEQR. We'll use both interchangeably here. In our capacity as consultants, AKRF has quite a bit of experience in both preparing SEQRA analyses for private development applications, as well as assisting municipalities throughout New York State in navigating the process by providing advisory services and technical review of SEQRA documents that come before municipal land use boards. We've done this presentation for CDRPC in the past, so we're assuming many of you listening in are members of various municipal boards. So you'll notice the format is sort of geared towards that audience, but even if you're not on a board, this should still be a helpful overview. So today's presentation is broken down into 4 main parts. We'll start with some history and background on the purpose and intent of SEQR, how it came about, the government decision makers that are required to undertake it, the areas of assessment that constitute the environment, quote unquote, under the regulations. Next, we'll discuss the general process through which SEQRA is applied to different projects, including how to classify a particular action, determining significance, and if a project requires preparation of an environmental impact statement, or EIS, the steps that are involved there. We'll wrap it up with some other common SEQRA concepts like segmentation, and we'll also cover some best practices to follow when assuming the role of lead agency. The presentation runs about 45 minutes, so ideally we'd like to save at the very end for some Q&A. And with that, I'm going to hand it over to Jason to start things off.
Great, thanks, Aaron. SEQR came into existence when Article 8 of the New York State Environmental Conservation Law was passed in 1975. At the time, when it enacted SEQR, the stated intent of the legislature was to declare a state policy to encourage productive and enjoyable harmony between humans and the environment. The legislature wanted to promote efforts which would prevent or eliminate damage to the environment and enhance human and community resources while enriching the understanding of ecological systems, natural, human, and community resources important to the people of New York State. SEQR regulations, which are actually quite extensive, are codified in Title VI, the New York Codes, Rules, and Regulations, Part 617. SEQR is both a procedural and a substantive law. It establishes a process to systematically consider environmental factors early in the planning stages of actions that are directly undertaken, funded, or approved by local, regional, and state agencies. Through the SEQRA process and by incorporating environmental review early on in the planning stages, projects can actually be modified as needed in an effort to avoid adverse impacts on the environment. This process allows for public and agency participation and coordination, increasing the efficiency of project planning. So, indeed, SEQRA seeks to find a suitable balance of environmental, social, and economic factors when planning and decision-making processes are undertaken. So what is a hard look? The hard look requirement is based on case law from a 1979 New York State Appellate Division case, Holmes versus New York State Urban Development Corp., which I'll refer to as UDC. So in that case, there was a new large sports stadium proposed to be constructed in Syracuse, New York, at Syracuse University. The UDC didn't require or review any traffic and parking mitigation plans, despite the expected capacity of the stadium being over 15,000 people, or any traffic studies before it issued a negative declaration for the building of the stadium. So instead, UDC actually only relied upon general assurances that after hypothetical problems were developed, the university and the city of Syracuse would adequately mitigate the problems by some unspecified appropriate actions. Those general assurances provided no actual support that the construction of the stadium would not have significant adverse impacts on traffic and parking. Thus, the UDC did not undertake the required hard look. So we have to ask, what must a hard look do? A hard look must identify relevant areas of environmental concern and must establish what's called a reasoned elaboration. That is a clearly written elaboration of key facts surrounding the determination and establishing a clear record of the process, as well as a well-reasoned rationale for the determination. The agency must clearly document how it reached its ultimate conclusion. A takeaway from the Holmes case is that it's not sufficient to simply assert that problems will be mitigated when they arise. In fact, by requiring a hard look, even if some form of mitigation had already been planned, the hard look process can even further change the project such that the changes themselves can mitigate potential problems. So when does SEQRA apply? The SEQRA process must be undertaken whenever an action is directly undertaken by an agency, involves funding by an agency, or requires discretionary approval from an agency or local board, such as a planning board, zoning board, or architectural review board. Some examples of discretionary approvals could include the approval of a site plan, a special permit, a wetland permit, a variance, or a use permit, among others. It's important to understand how SEQRA regulations define environment, because that definition is rather expansive. Environment's defined as the physical conditions that will be affected by a proposed action. And these can include land, air, water, minerals, flora and fauna, which is a common consideration for undeveloped parcels, noise, and that can include construction noise or operational noise, and can depend on whether there are sensitive receptors nearby, resources of agricultural, archaeological, historic, or aesthetic significance, and these might include properties on national or state historic registers, as well as scenic views, existing patterns of population concentration, distribution, or growth, existing community or neighborhood character, including local architectural styles and scales, as well as human health, and that could be impacted by construction or operation of proposed action. Construction impacts on human health could include the release of fugitive dust or noxious fumes, or the creation of nuisance noise. Areas of environmental assessment contemplated by SEQRA are extensive as well. They can include many. Socioeconomics, which might include displacement of housing or businesses, and could also include provisions for affordable housing, though that's typically considered a benefit, and I think we'd all agree. Community facilities, and this includes police, fire, and EMS services, schools, sewer, trash, water, and electric utilities. Some considerations include the capacity of those facilities to absorb new residents and their associated impact, if local providers have expressed concerns, as well as school children generation, an often controversial topic that planning boards focus on and residents are very vocal about. There's also traffic and transportation. This might include vehicle trips generated by the proposed action, traffic volumes, impacts on intersections, and access to public transit options. There's also visual impacts. This includes impacts on scenic views, shadows, and how the proposed action fits into the surrounding visual context. Community character. This could focus on conformity with comprehensive plans, town plans, or regional plans. So for example, many of AKRF's projects are in Westchester County, and those projects have to consider and conform with the county's comprehensive plan, Westchester 2025. Finally, public health. For example, a site could have existing contamination, so environmental assessments might include how remediation would be handled in the event that the agency reviewing the proposed action determines remediation is necessary. Our next consideration is who has to comply with SEQR. Those who have to comply include state agencies, local governments, including all of their boards, and financing agencies such as industrial development agencies and housing development corporations. As to its enforcement, SEQR is a self-certifying law. There's no SEQR police. The SEQR statute did not provide the DEC or any other agency with administrative or enforcement authority to review SEQR implementation or decisions by other agencies, which creates a bit of a challenge. While the DEC is charged with administering SEQR, it can't force another agency to comply. So actual oversight and enforcement falls to interested citizens and community groups, such as activist organizations and other interested groups. SEQR decisions can be challenged, however. Challenge is undertaken through a specific court proceeding, which some of you may have heard of before, called an Article 78 proceeding. That takes place in New York State Supreme Court. It's a formal legal challenge of the final decision made by an administrative agency. And an Article 78 proceeding, much like SEQR, has its own strict procedural and substantive requirements. Additionally, involved agencies can dispute a lead agency's findings, but in our experience, that's not that common of an occurrence. So how and when does SEQR begin? The SEQR process runs concurrently with an application for development. However, that's not the only time SEQR is implicated. The process should also be initiated concurrently with the circulation of draft local laws or comprehensive plan amendments. All development applications must be accompanied by an environmental assessment form, often referred to as an EAF. There are 3 parts to an EAF, Part 1, Part 2, and Part 3, and those are completed sequentially. The EAF Part 1 can be a short form, which is about 2.5 pages of required questions and information, or a full form, which is 13 pages and a much more comprehensive set of questions. And that depends on the type of proposed action, which we'll detail later in this conversation. Aaron will now discuss how to determine the type of a SEQR action.
Thanks, Jason. So under SEQR, we have 3 types of actions that a particular undertaking can fall under. Type 1 actions, by definition, are those presumed to have the most potential to result in environmental impacts. And we'll get into the specific thresholds established through the regulations later. It's important to keep in mind that not all Type 1 actions will end up requiring preparation of an EIS. Type 2 actions, by definition, are those that have no potential for environmental impacts. If an action meets any of the categories specified in the regulations, the SEQR process effectively ends with the determination by the lead agency that it is a Type 2. No short or full EAF is required for a Type 2 action. Unlisted actions are those not identified in either of the Type 1 or Type 2 lists and may have the potential for environmental impacts, but again, may not necessarily require an EAS be prepared. So section 617.4 of the regulations is where you're going to find the full list of Type 1 actions. And towards the end of this slide deck, we do have some links to help you navigate those if you want to take a look at the full list. So we do encourage you to do that. There's lots of examples, but I'll go over the most common on this slide. Type 1 projects tend to be on the larger side and therefore more likely to have the potential for significant adverse impacts. Again, not all of them would necessarily require that an EIS be prepared. That would depend on the lead agency's determination of significance, which we'll go over a little bit later. The Type 1 list includes specific thresholds for actions that are based on the size of a community's population. So let's start with the example we have on this slide of a residential development in a community with a population of 150,000 people or less. So if you're working in a municipality like this, and a developer comes in with 200 units of residential housing or more, even if the project would be connected to an existing infrastructure, systems, power, utilities, sewer, water is all there, it would be automatically still a Type 1 action. This threshold used to be 250 units actually before the amendments to SEQRA in 2019. Type 1 also comes into play when you're dealing with a site that has historic resource considerations. Specifically, if the site itself contains a state or national register eligible or listed historic structure, and or if the site is located within an eligible or listed historic district. In such cases, an action involving the property can be considered type 1, but only if 25% of another type 1 threshold is exceeded. A little confusing, but let's take a little, the residential project that I had before as an example. So 200 units in a municipality with 150,000 persons or less. 25% of 200 is 50. So if the municipality in question meets this population threshold, and you're dealing with an eligible or listed historic district, or the building that's there is a historic resource, that would mean that 50 or more units proposed on that particular site would make it a type 1 action. This 25% threshold as it relates to historic is kind of new. It came about in the 2018 to 2019 amendments. Prior to that change, even if an applicant was proposing a couple of units in a situation like this, it would still be a type 1 action. Back then, no longer the case. Some other common examples of type 1 actions are a municipality's adoption of a comp plan, a zoning change affecting 25 or more acres, or the physical alteration of 10 or more acres for a non-residential project. So type 2 actions you'll find in section 617.5 of the regulations. These are actions essentially exempt from any consideration of impacts under SEQRA. In other words, the SEQRA process effectively ends at this determination. Again, the list is pretty long in the regulations, but we've consolidated here some common examples. And I've also shown some recent additions based on the SEQRA updates. Those are the ones with the asterisks. Some common type 2s include rehabilitation of an apartment building with no change in density, also known as replacement in kind, individual variances or lot line adjustments, new construction of a 1, 2, or 3 family home on an approved lot, new construction of a small commercial building with less than 4,000 square feet of floor area. You'll notice that a lot of these recent additions with the asterisks deal with green infrastructure and solar activities, issues that are, a lot of communities across the state are seeing and dealing with in recent years. So this was DEC's attempt to try to streamline some of these types of projects, provided that these descriptions are met. Interestingly, agencies are permitted under the law to adopt their own list of type 2 actions that are specific to their operations. It's a rare occurrence due to the process involved in doing so, but through some of the work that we do at AKRF, we do a lot of New York City projects, and we know that certain New York City agencies, for example, given the volume of activities that they encounter in a given year, which requires SEQRA for various reasons, they've adopted their own type 2 lists as part of their city charter. They're a little more detailed, specific for the city, supplemental to the state's regs. Another important thing to keep in mind with type 2s is they can be subject to interpretation. So it's always a good practice to consult with legal counsel or a code enforcement officer before you make that determination. So now that you're a little more familiar with what constitutes type 1 and type 2, the rule of thumb to follow if you can't type a project given those 2 lists is to play it safe and call it an unlisted action. Examples can include a minor subdivision, multifamily apartment buildings with less than 50 units, and small scale retail or restaurant establishments that are not small enough to be type 2, but not large enough to be type 1. So the next step after you've typed the action is to establish your lead agency designation. When reviewing a type 1 or unlisted action, the lead agency needs to formally declare intent to be lead agency for the SEQRA review and to circulate application materials to involved and interested agencies. So let's go over what involved versus interested means. Involved agencies are those agencies that, in addition to a lead agency's authority, also have an approval or permitting role in the project. Take, for example, the DOT having to approve a driveway and issuing a highway work permit. That's a discretionary approval, so they're an involved agency. Interested agencies, on the other hand, include those that may not have an authority to permit or approve or any discretionary approval, but the lead agency may still value their input during the process for other reasons. And examples of an interested agency could be your local service providers, police, fire, EMS, or a conservation group. Like I said previously, when you're dealing with a type 2 action, you're basically done, but it's advisable to get that determination in writing for the record, either by voting through resolution at a meeting or issuing a memo to the project's file. When declaring intent to serve as lead, it is best practice for the assumed lead agency to notify all other involved agencies of this intent. At a minimum, the part 1 of the EAF should be circulated along with a copy of the application itself. A map depicting the location of the proposed action is also pretty important. Pursuant to the regulations, the assumed lead agency should allow 30 days for a response. If no response is received, it can be assumed there are no disputes. While very rare, it is possible that an involved agency could dispute and request to be lead themselves or recommend another agency. In such cases, the DEC commissioner can get involved to help resolve that dispute. Many municipalities use this standard form that's shown here on the right side of the slide to solicit responses on their intent to be a lead agency. So once you declare yourself as lead agency and to undertake a SEQRA review, and there's no objections within that 30-day window, the lead agency can then begin reviewing a submitted EAF, environmental assessment forms. There's 2 types of EAFs, the short form and the full form, as Jason covered earlier. The short form is required for all unlisted actions. And part 1 of the short form consists of about 2.5 pages of information to fill out, while the full form is required for all type 1 actions and is more involved, with the form containing about 13 pages of project information. Part 1 of either form is always typically prepared by the applicant with their submission to their applicable board. Part 2 of the EAF in either form is completed by the lead agency and contains a series of questions on environmental categories to help guide the lead agency's eventual determination of significance. On the full form, which is more involved, questions can be answered by checking either moderate to large impact or no or small impact. The lead agency can request supplemental information or technical studies if they believe a moderate to large impact could occur related to a particular area. Jason will present some examples of the supplemental information commonly requested. Part 3 of the EAF, also completed by the lead agency, includes a determination of significance and a reasoned elaboration for why that determination was made, often citing the findings of supplemental technical studies completed by the applicant at the request of the lead agency. A helpful tool that applicants should be familiar with, and we included it on this slide just as an FYI, and that's for completing part 1s of the form. It's called the DEC's EAF Mapper. It's found online. It allows you to choose a location of your project site, an interactive map. It generates a partially completed part 1 by gathering certain information from a search of agency databases and maps. Some stuff is not always easily found by the applicant, and it's always good to use the mapper to verify because the government databases get automatically thrown right into the form for you. For example, areas of potentially that are sensitive for threatened and endangered species. If the site's a brownfield site, it'll show up in that database. Whether or not the site falls within a critical environmental area as defined by DEC, or if the site falls within a historic district or an area sensitive for archaeology. So I'm going to turn it back over to Jason now. He'll go over the types of supplemental studies, technical reports that a lead agency can request from an applicant as they review either a short or full EAF.
Great, thanks, Aaron. So even if a lead agency is just reviewing an EAF and issuing a negative declaration as the determination of significance, that lead agency can still ask the applicant for supplemental information. And most commonly, we've seen that information asked for as an addendum to the EAF. Supplemental information is commonly required for non-EIS projects. That information is often requested in response to local concerns, for instance. Those concerns arise because local residents and local authorities, they're more familiar with an area, the conditions, the views, local norms, traffic patterns, and similar things. Local concerns might also include requests to examine exterior site lighting, visual resources in the form of photo simulations, traffic and parking volumes, and natural resources. Supplemental information is also commonly requested in response to agency concerns, not just lead agency. This could include concerns related to traffic, and that might come from the New York State DOT or a county highway department, natural resources such as threatened or endangered species, and that request might be made by the DEC, historic resources, and that could be asked for by SHPO, the State Historic Preservation Office, since certain actions require submission to SHPO, and in those instances, applicants might actually be asked to obtain what's called a letter of no effect. So the next few slides review some examples of supplemental information that was requested on projects our firm has worked on. So in this example, supplementary information was requested in the form of a visual simulation to show the visual impact of a proposed wind farm in Steuben County, New York. The photo on the left shows the existing condition, residential and commercial structures with a treed ridgeline behind them. Photo on the right simulates what the area would look like if wind turbines were installed on the ridgeline. And notably, the visual impact focuses on public viewpoints, that is, views the public might experience from public spaces such as parks and roads, but not on private views that one might experience for example, from their own backyard. So in this example, similarly, supplemental information was requested in the form of another visual simulation to show the impact of a solar project in Montgomery County. Photo on the left shows the existing condition in winter of a roadway and an undeveloped field behind it. And the photo on the right simulates what the area would look like if a solar farm were installed and developed on the field. Simulations such as these provide the lead agency with a much clearer understanding of how a proposed project might impact the visual landscape of the area, and they can be especially informative as the lead agency makes its determination. Aaron, can you play the simulation here? Sure, great. So in this example, supplementary information was requested in the form of a simulation of complete street design in New Rochelle, New York. This project was the reconstruction of a road to improve interactions between vehicles and pedestrians. The simulation demonstrates the relationships between vehicles and pedestrians upon final design. It shows how various modalities, including vehicles, public transit options, bicyclists, and pedestrians can share a road in a safe and efficient manner. It also shows, as you can see here, various bike lanes, crosswalks, curb cuts, mid-block crossings, and pedestrian islands that add to the interactions between the pedestrians and the drivers, as well as the safety for those using the roadway. Beyond this example and the ones we just went through, there's other supplementary information a lead agency might ask for. So that could be an analysis of noise, especially if a project will be in close proximity to residential receptors. The lead agency might ask for a traffic impact study, demonstrating trip generation, levels of service at intersections near a project. And this is all to say an applicant should have professionals ready, willing, and able to present technical reports at the request of the lead agency. So now Aaron will go over how a lead agency makes a determination of significance.
Sure. So let's now assume that the lead agency has thoroughly reviewed an EAF along with any supplemental studies, technical reports that the applicant was asked to generate. The SEQRA regulations include a list of guidance criteria to assist a lead agency in determining significance of environmental impact. This slide does not show the full list, but if the lead agency is convinced that any of these criteria are applicable to the action being reviewed, it could be grounds for a positive declaration, which requires an environmental impact statement. So let's walk through some of these. substantial effects on water quality or substantial increases in traffic, noise, or air pollution above the existing condition. You could have destruction of large quantities of habitat known to contain threatened or endangered species. There could be a material conflict with what a community's comprehensive plan recommends for the site or the neighborhood. The project could present a contextual conflict with an on-site or nearby historic or aesthetic resource. Maybe the height obscures view of a visual resource, or the architectural style of a building is out of character with a historic building next door. The project is expected to generate a large increase in the number of people to a place for more than a few days. In other words, an influx of people that can be perceived as permanent rather than intermittent. Using information gathered through the EAF process. Sorry, excuse me. Water break. And this guidance on significance, the lead agency makes an informed decision on significance and can proceed down a couple of different paths. So one path could be the negative declaration, where the lead agency determines that the action or project has no potential for significant adverse impacts, or they determine that through their EAF review process, if it's thorough enough, the applicant has modified the project in response to feedback or concerns from the lead agency and or the public enough to avoid, minimize, or mitigate potential impacts through their design. If a negative declaration is issued for a type 1 action, the DEC requires the lead agency to publish a notice of negative declaration on their what's called their environmental notice bulletin, or ENB. The ENB is a database of SEQRA actions published weekly, and can be a pretty useful place for the public to see what types of projects might be happening in their region. If, however, one or more potential significant adverse impacts are identified, again, utilizing the guiding criteria that we went over earlier, the positive declaration can be issued, which requires the applicant to prepare a draft environmental impact statement, or DEIS. Through the EIS process, those potential impacts are thoroughly evaluated and specific mitigation is developed. We have some additional slides on the DEIS process, which Jason will go over later. Positive declarations can be issued for either type 1 or unlisted actions, and they must also be published in the ENB. So here we have just a flow chart to kind of go over what we've covered so far, the typical process. So let's start with a type 2. That's the easiest, right? So you're classifying the action, you determine it's type 2, follow the line down. You're pretty much done with SEQRA. Just make sure you document that accordingly. You've consulted the right folks to confirm that that's the right determination. Keep it on file, maybe even pass a resolution to indicate that that's what it is, citing the specific regulation citation. So if we have an unlisted action, we will have to complete the short EAF for any unlisted actions, right? You can also coordinate with involved agencies, but it's more appropriate to coordinate type 1s. It's not totally always done for unlisted, but it is a good practice to do that, coordinating with the involved agencies. Following review of the EAF that they prepared, the short EAF, any supplemental reports you needed them to look at or prepare, you move on to your determination of significance, which can go in either direction, negative declaration or positive declaration. If you're going the negative declaration route, the process ends. If you're going to the positive declaration route, you have to prepare an EIS, and that process, which Jason's going to touch on, issue findings, and then the SEQRA process ends. Type 1 follows very similar to what I just described, except you have that long EAF that's required, and you get to the same points.
So we discussed the issuance of a positive declaration. After the positive declaration is issued, the applicant is directed to prepare the environmental impact statement, or EIS. Generally speaking, the EIS is a document that analyzes the full range of potentially significant adverse impacts of a proposed action and how those impacts could be avoided or mitigated. The EIS is written, hopefully, in concise, plain language with the aim that the general public can read and understand its contents. EIS provides a means for agencies to consider environmental factors at an earlier stage in the planning of an action and assists in their balancing of environmental issues with social and economic considerations in planning and decision-making. What the EIS does is it systematically considers that full range of potential impacts along with other aspects of project planning and design. It must identify and analyze the environmental impacts, evaluate alternatives to avoid one or more of the impacts, and discuss mitigation measures that could minimize the identified impacts. Under the EIS process, involved agencies are supposed to participate in the development of a single environmental record, hopefully, and rely on that record for their decision-making. The EIS also presents alternatives to a proposed project, and those alternatives are supposed to meet the purpose and need of the applicant while reducing the potentially significant adverse impacts. So how does an applicant even know what it must cover in the EIS? This is done through a process called scoping, and that establishes the roadmap for the EIS. The scoping process, along with the EAF review that Aaron talked about earlier, analyzes technical considerations focused on potential impacts and responds to public and agency concerns. The process can rule out areas that don't require analysis or merit examination, as they might not be applicable to the proposed action. So for example, a subdivision development of, let's say, 10 to 20 lots in an otherwise undeveloped area might not have a meaningful traffic impact because it might not generate enough vehicle trips to merit a traffic study. But the development of that same subdivision in an undeveloped area could significantly impact local flora and fauna. So the scope of the DEIS might not require a traffic study, but it could require analysis of impacts to plants and animals. A hearing on the DEIS scope is not required by SEQRA, but many municipalities that we work with choose to do so anyway. At a minimum, the municipalities must accept written comments on the scope from other agencies and from the public. And once that scope is adopted, the applicant has to follow it. And as we said, it'll serve as the roadmap for the environmental review. After the applicant has prepared the DEIS, it's reviewed by the lead agency. The review of the DEIS focuses only on what's called completeness with respect to the adopted scope. Thus, it's not a substantive review at this point, but a review of whether the DEIS is adequate to understand impacts and proposed mitigation strategies, and if all topics required by the scope have been covered. So critically, in determining completeness, the lead agency doesn't have to agree with the conclusions of the DEIS. The substantive commentary and review comes later on in the process. The DEIS is then circulated to interested and involved agencies. It has to be posted publicly, often on a town's website or the website of the lead agency. Since February 2006, New York State's required posting of SEQRA documents on publicly accessible websites. The DEIS must also be made available for in-person review, but the location for doing that depends on the preference of the lead agency. So it could be, for instance, at the town hall, the offices of a planning board, or a local library. And even though we live in 2022 in internet modern times, the requirement makes sense because it makes the DEIS accessible to those who might not have internet access or older members of the local population who aren't comfortable navigating a document like that online. So once the DEIS is accepted as complete for purposes of public review, the lead agency typically schedules a public hearing. While not required, this happens very frequently, and it's a very good idea to do so. That public hearing requires posting of a notice in the ENB, on the project website, as well as in a local newspaper. The hearing can be no sooner than 14 days before, but no later than 60 days after publication of the notice. It's very good practice to communicate expectations to attendees of that meeting. They should be advised personal attacks won't be tolerated. Concerns should focus on the content of the EIS, and they should be told to recount what the scope requirements were and that there might be time limits for the speakers. So it's a very good idea to have these ground rules established, both for flow and for practicality. A stenographer could also and should also be on hand to record the public comments. As to written comments on the DEIS, the lead agency sets a comment period, which has to be at least 10 days following the close of the hearing, but most often this is set as 20 or 30 days to allow the public time to understand and digest what they've reviewed and offer their commentary. And all these comments made at the public hearing, as well as written, will be responded to later on in the FEIS, which Aaron will now get into and explain.
Thank you. So following the close of the DEIS comment period, this is where you prepare the FEIS, final EIS. While it is common for the applicant to prepare the initial FEIS, it is ultimately the lead agency's document to adopt. Very important to remember that. It is important that the FEIS that gets adopted be in the voice of the lead agency. So if you're the planning board, for example, it has to be in the voice of the planning board, avoiding combative tone in response to certain comments, for example. The FEIS should, as clearly and concisely as possible, lay out the conclusions reached based on the analysis completed. Regarding the comments that are received on the draft EIS, the final EIS must include a comprehensive response to all substantive comments that were received on the DEIS, made both at the hearing and in writing before the close of the comment period. As a best practice, the substantive comments received should be organized by topic or chapter of the DEIS, and copies of the stenographer's hearing transcript, if you had one, and all written comments that were received, either as letters or emails, should also go in the appendix of the FEIS. In reviewing the response to comments, the lead agency can request additional information if a response is not considered adequate. And one thing that we like to do, it's not a requirement, but when we prepare an FEIS, in the comments that are in the back, in the appendix, we identify those that are relevant to the scope of the EIS. We box them with like a red box and we say, this is whatever topic, it's on page, whatever. So it's kind of like an index, so that, certain people that did comments can actually find their comments and ensure that they did get a response. If technical studies are done by the applicant in response to specific comments, those should also be included as part of the FEIS record. In response to comments or issues raised during the DEIS review process, the applicant may decide to modify or reduce the scope of a project to avoid, minimize, or mitigate potential impacts. For example, if they want to pull the proposed disturbance away from a wetland area or a wetland buffer, a site plan modification. There's no requirement that a public hearing be held on an FEIS once it's deemed complete and accepted by the lead agency. Following adoption of the FEIS, it is distributed to the same interested and involved agencies that received the DEIS, and there's a minimum 10-day waiting period required prior to the lead agency then issuing a finding statement, which I'll go over next. For an action subject to the EIS process, the final step in the process, and you saw from that flow chart, is the lead agency's adoption of what's called a finding statement. In addition to the lead agency, all agencies that we identified as involved, again, those that have permitting authority, other discretionary approvals, they're also required to issue their own findings. The lead agency can either adopt negative or positive findings. If adopting negative findings, the lead agency is certifying that the action is not approvable after consideration of the FEIS, and the reason must be thoroughly documented in the finding statement. By adopting negative findings, a lead agency is certifying that the proposed action will not achieve a balance between the protection of the environment and the need to accommodate social and economic considerations. A positive finding statement is adopted if the lead agency determines that the action can be approved after considering the FEIS. So contrary to a negative finding statement, in this case, a lead agency is certifying that they have weighed and balanced the potential impacts and the measures identified in the FEIS to minimize or mitigate those impacts to the maximum extent practicable, and they are consistent with social, economic, and other considerations. After positive findings are adopted, SEQRA is completed and any specific discretionary actions like a subdivision or site plan approval process can happen. So now that we've walked through highlights of the process, we always feel it's good to hit on the topic of what's called segmentation and how to best avoid it. Lead agencies are often faced with a problem of how to address a complex action involving a number of related components that may not be presented or applied for at the same time. So let's look at some examples when this occurs. There may be a series of applications for the same project, like a zoning checks change that happens first, followed by a subdivision or a site plan approval. There could be a large project with many phases to be constructed over a number of years, and those phases are not speculative, but have been publicly disclosed. The same developer could have concurrent projects planned on separate sites, both requiring similar actions. When encountered with these kinds of situations, it's critical to understand that SEQRA requires an evaluation of the whole action. And if their proposals or parts of proposals related closely enough to be, in effect, a single course of action, the environmental review should not be segmented, but combined as a whole action and evaluated accordingly. So segmentation, or the perception of it, should be avoided since it can serve as grounds for a legal challenge. Here we have some basic test questions from the SEQRA regulations, right out of the regs, to determine if the segmentation possibility is happening. If the answer to any of these is yes, an agency should be concerned that segmentation is taking place. So let's look at these. 1, is there a common purpose or goal for each segment? The timing. Number 2, is there a common reason for each segment being completed at or about the same time? For example, there may be an application deadline for funding from another agency, and that application includes each segment. 3, is there a common geographic location involved? Each segment could be within the same municipality and not very far apart. Number 4, do the activities separately share a common impact that may, if considered as one project, result in a potentially significant adverse impact, even if the impacts of the separate activities are not necessarily significant by themselves? A big one that comes up in this situation could be traffic, cumulative traffic issues. Number 5, are the different segments under the same ownership? Number 6, are any phases considered functionally dependent on each other? In other words, can one cannot feasibly happen without the other? And lastly, the issue of inducement. Does the approval of one part or phase commit the lead agency to approve other phases? So there's some limited circumstances where segmenting reviews may be justified, or what's called permissible segmentation. When considered together, here are some circumstances that may warrant permissible segmentation for a phase project. Say the information on future project phases may be too speculative, meaning there's no designs to share, there's no tangible timetable for the later phase, or it's just merely an idea. The future phase may never occur, or future phases are functionally independent of the initial phase, so one does not need to be built to support the other. If it can be shown that the segmented approach to the environmental review will be no less protective of the environment, it may be permissible. Again, a best practice here when segmentation is a concern is to consult with legal counsel, keep good records, document in writing the reason for making the decision. So in closing, so we've summarized some best practices on this slide to help for you to keep in mind when undertaking a review, environmental review under SEQRA. First, one of the easiest targets for an Article 78 challenge is the board's failure to comply with the regulations. So compliance is critical. The best way to ensure compliance is to document everything. If you're using professional consultants to assist with technical review on traffic studies or anything else that the applicant submits, those consultants require them to issue their comment memos for discussion before every meeting is happening. You can even post those online. When it comes time to make a determination of significance, the negative declaration, or positive declaration, the reasoning behind the decision should be documented in writing, citing the guidance criteria. Don't hesitate to express the balance between the benefits of a particular project against the potential impacts. As we went over before, this is one of those critical foundations of making findings. And remember that SEQRA requires that hard look or reasoned elaboration that all relevant areas of environmental concern were thoroughly analyzed upfront and have met the appropriate standard. If you remember from Jason talking about the Holmes case, deferring a traffic study to, let's see what happens, it's not going to fly. You have to make sure that the hard look is taking place. Keeping the public informed throughout the process is important as well. If the lead agency is deliberating on a long EAF with supplemental information or studies over the course of several meetings, several months, that EAF is likely to evolve over time, and it should be posted each time it's submitted or available for public review, so the latest information is available. Similarly, if an EIS is being done, municipal websites are also important, not only as a place to store the draft and final EIS, but also to keep everyone informed of the process, like when scoping hearing is happening, when the DEIS has been accepted as complete and available for review, when the hearing is going to happen, how long the comment period is, when it starts and ends. And lastly, be consistent, which good record keeping can facilitate. Have a good understanding of the type 1 and type 2 lists, so applications are classified in a consistent manner. You don't want to, not be consistent between different projects. If a similar project comes back and you type 1 it when it could be a type 2, that you don't want to get into that situation. You can also develop standard forms to help streamline some of the processes and make sure all required steps are being followed. So lastly, we just provided this slide. All these links work, and we will have the PowerPoint available, as Martin said. So the full list, the full regulations found at Part 617. We have the SEQRA cookbook, which was last updated in 2019 when the SEQRA updates were made. It's a good resource. It has a flow chart with some guidance provided on each step. The SEQRA handbook, the 4th edition, most recent from 2020, that has particular really good technical guidance and also some like Q&A, frequently asked questions and stuff like that. The EAF workbooks are also really helpful, particularly if you're dealing with a long form and how to get those part 2 answers, those questions answered in the right way, what to do to get there. And lastly, we have a couple of examples of some DEC guidance. There's a specific guidance DEC has put out for how to assess visual impacts. There's also a pretty robust noise policy that they have available. So I think these are useful tools. Feel free to take a look at those on your own time. And with that, I think we are ready to take Q&A.
Yeah, we've got a couple questions already posted in the Q&A, and there comes another one. So they're starting to come through. Just remind folks, use the Q&A or the chat, post your questions, and we'll be sure to get to them before we depart today. First question, when applicants request coordinated versus uncoordinated review, when can applicants request coordinated versus uncoordinated review? Is that the same as segmentation?
No, it's not the same as segmentation. The best way to know about coordinating review is who are your agencies involved. Like if you know that there's going to be a permit issued by the DEC or the DOT, even if it's an unlisted action and not very complicated project, it's good to coordinate with them, which means, and the way to do that is really just when you make the determination of what type of action it is and you go to circulate, you specify in that circulation that we're calling it coordinated. And then you make sure you have your list of agencies and if you have a planning board secretary or whoever does the distribution, gets it out to those agencies and makes sure they understand that you're making it coordinated.
Great, thank you. The next question, how long do people have what's the time frame for challenging a SEQRA determination? And if a step is missed in the review process, does that affect the timeline for challenging the determination?
The Article 78 does have a time frame. I believe it. Yeah, I think it's like 4 months. Yeah, there's a 4-month after action is made, like after findings are made. You have a 4-month period, in which case you can bring an Article 78 challenge. If that 4 months passes and that doesn't happen, there really is no grounds to do it. What was the second part of the question?
The second part was regarding if there's a step missed in that review process, does that affect the timeline for challenging the determination?
Again, the 4 months is the standard, but what you can do if you want to go against a project is take a look at the process. Did they follow all the steps? If you notice that they didn't, even if something as simple as you didn't post to the ENB could be, that could be raised as an issue. I've seen that happen before on controversial projects.
Thanks. And bear with me, this is a lengthy question, and this is the last one that's come in so far. Okay. During the scoping portion, who is the final arbiter of what is included in the EIS? Is it up to the lead agency to determine whether to include a potential impact, say traffic in the EIS, even if it doesn't seem on its face to have a negative impact? The second part of the item is more of a statement or a question. Or is the determination more of a political decision, like accounting for public pressure? Person writes, I assume most decisions would be in favor of including it in the EIS to avoid an Article 78 challenge, but that also seems to put a lot of power in the public stopping projects. So a question about navigating that process, developing kind of a framework for what to include and some parameters.
Yeah,
whether
so the lead agency ultimately adopts what's called the final scope, and that comes after the scoping hearing, if you have one, and the draft scope is reviewed by the public. And when the draft scope's developed, usually there's 2 ways you can take it, right? You could have a giant project that comes in and you might just tell the applicant, look, we don't want to look at the EAF really. I think we're just going to do an EIS and cover every single topic. Don't worry about doing an EAF or supplemental studies for now. We're just going to go ahead and pause deck this. We want the scope to have every single topic that is covered. That's one way that you guarantee that everything gets in. The other way is you could allow the applicant to present their additional information as you go along, and the traffic study could be one of those things, and it could show, hey, look, this is it's not reaching the DEC's and DOT's thresholds for a traffic study. It doesn't have 100 peak trips and 100 trips in a peak hour. So it really doesn't warrant a detailed traffic study. And, there could be some back and forth with that. You could have the consultants weigh in, and if you have them, to see if that's accurate and if you agree. And if it's really through the EAF process and a non-issue, it doesn't need to be in the scope technically. But again, if you're upfront enough at the beginning saying, look, we want to make sure all the topics are covered and we want to scope this and be open as possible, you could do it on the onset. But some boards like to give the applicant an opportunity to go through some technical reports first.
I think the one thing I'll add is I think the last part of that question was, does this put power in the public's hands to stop projects? Just because something's included in the scope and they have to analyze it doesn't ultimately stop the project. It just gives an opportunity for further mitigation to be considered and for the applicant to propose mitigation tactics. So it's practically better to err on the side of including it, because then it just creates a public debate and a review by the lead agency of, is this mitigation sufficient or not?
Right, and mitigation.
When in doubt, put it in the record.
Right, and again, mitigation can be by design, like the project could change throughout the process and get reduced, and that's enough to mitigate an impact sometimes. Or there could be specific mitigation measures that come out of the EIS. Like, we know this intersection has to have a signal timing adjustment of whatever to ensure a level of service A or whatever it may be. Those are more specific. So there's mitigation varies, but like Jason said, he's right on the money.
That's great. Well, I want to, that concludes the questions portion of the webinar. I do want to mention, I put the link to the Eventbrite page where people can access a video archive. So immediately following this, as soon as that renders, it'll be available. And if you could send the presentation as well, I'll make sure to include that in the presentation materials. I really want to thank Aaron and Jason and AKRF for their support. We literally could not do it without the support of sponsors and speakers for this program. AKRF is wearing both hats, presenting and sponsoring the series. So I really do want to thank you guys and your team at AKRF for supporting this event and bringing this so we can provide these planning and zoning credits to folks and make sure we're keeping skills sharp. I do want to give a plug for next week. On Wednesday, May 18th, also at 1 o'clock, we're going to have a session on short-term rentals, balancing local impacts and economic growth. Real hot topic, and many communities are struggling with how to regulate short-term rentals and things like Vrbo and Airbnb that are oftentimes creating conflicts in the community. So we'll have a session next Wednesday at 1 o'clock. So we hope you can join us. Until then, Aaron, Jason, thank you so much for sharing your knowledge to us and being really thorough about SEQRA. I appreciate the afternoon. Hopefully folks will get out and enjoy the sunshine because it looks to be a beautiful day. So thanks for bearing with us. We will see you next Wednesday at 1 o'clock.
Thank you so much.
Thanks, everybody. Have a great weekend.
Bye-bye, guys. Thanks a ton.
Yep.